July 2nd, 2024. Well, the long-awaited presidential immunity decision by the Supreme Court has come down, and it's sort of interesting that, of course, the Democrats have absolutely blown a fuse over it, complete with the um, the Biden short 5-minute speech where he condemns the Supreme Court pretty much. I guess he doesn't realize that the decision applies to him too. So if he's worried about what might happen if he loses the election, maybe, oh, I don't know. But actually, I've also heard that Trump has, his legal team has tried to use this decision immediately in the case in New York about the payments to the lawyer and all that. So we'll see where that goes. My own read on it is that the Democrat reaction, including the response opinion on the Supreme Court, is a bunch of hysteria and nonsense, actually. Unless this thing were to develop in a way, as is, all it does is just state the way it's always been, but make it formal, where before it was informal. And that is, the president is immune to prosecution for official acts of office, basically, that are really that are appropriate to his role. So, for instance, you can't prosecute Obama for murder because he killed an American citizen in a drone attack overseas, because that American citizen was also in a terrorist group. So, as an example, it would give Obama that protection, as an example. But it doesn't. For instance, if a president were to commit a regular crime in his own personal life, such as cheating on his income taxes, a business fraud against somebody, and that sort of thing, or the examples they have, killing somebody who he doesn't like, that would obviously not be protected. They're trying to suggest if he used government agents to do it, that maybe that would be protected. I doubt that would either. And here's the thing that seems to be missing in a lot of the Democrats' responses is the fact is who would decide what is an official act and what is a personal act, because the personal acts they're saying are not protected. So, although there is a Justice Department ruling that's been applied for years, that you can't actually prosecute a sitting president while he's in office. For instance, that was applied in Trump's case when he was in, again, and it was applied in other presidents' cases as well. I think going back to Nixon, for instance. So this is, but after you're out, it's fair game, so to speak, if it's a personal thing. So, and of course, who decides whether it's personal or official? Well, the court system. So in reality, it's still going to follow the same court systems that we're dealing with already to judge this. So what's going to happen is the case has then been, in the case of Trump, has been remanded back down to district court with the same Democrat judge who was very hostile to Trump and was very hostile to all the January 6th defendants, etc. And it's going to be for her to sort out what in the charges is personal or not. So if you like these videos, please give me a like. We need to have more. That helps with the algorithm. Looking for more subscribers as always. And of course, I will post this on. You can find me on Rumble as well under the same name, and the information's in the description. So so that's the kind of the situation. It isn't a get out of jail free card for Trump, actually, so to speak. It's and of course, they keep saying that nobody's above the law, but I guess Hillary Clinton was above the law because they said no reasonable prosecutor would bring the case when she did something that's very analogous to the charges in the Miami, I think it's not Miami, but the Florida case, if you will, the documents. So, but I think I don't expect that Trump is going to have much luck with trying to overturn the New York conviction based on this Supreme Court decision. The rationale for overturning it is something totally, is just normal constitutional amendments, procedural issues, and so forth. I think there's a Sixth Amendment case that's pretty clear cut because he was never found guilty of any specific crime that would enhance it to a felony. They were given a choice of any one of three, but they didn't have to specify. So unspecified, I think it violates previous precedents, what I've heard. There's a lot of other things wrong with that case too. The judge clearly should have been recused from the case because he's clearly biased and all that stuff. No, but nonetheless, he's going to make this move. So I don't. It's kind of interesting that they're going to try to use it for that, but I don't think the New York courts are going to agree with that. However, it might just possibly be useful in the following way. I just thought of this. It might be a way to get it into federal court and then bring up other issues as well in that presentation. In other words, bring up that issue, which they'll say no, it's personal, but then bring up the Sixth Amendment issue and the other issues of that sort in the federal case, and then get a hearing on it, and that's how it might be useful. That is a way to kind of get in the game. But flat out, they're not going to say that he was immune on that act if it was in fact criminal. The fact is, of course, I don't think it was. But in fact, it's quite possible. Well, let's not go into that. We've talked about that enough, I think, as far as the New York thing. I don't think it has any bearing at all, really, for the most part, maybe a little bit on the documents case, but I'd have to go into detail what all's in that case. If part of the case is the idea that he removed him from the White House, you could argue that maybe that removal occurred while he was still president, and you might be able to argue that it's appropriate for president to remove personal effects, but really the truth of that is that it was an accident anyhow, that happened. What wasn't an accident is what happened after he was out of office. But that's a complicated case. It's ongoing with a lot of motions, including one that the appointment of the special counsel itself was improper because he has not been confirmed by the Congress, the Senate. However, other defendants in these special prosecutor cases historically have failed to be able to make that case. But let's get it won't. But on the D.C. case, which is the main issue, what we've really got is we've basically continued the postponement. Now, as I'd mentioned in previous videos, I have my own preferred idea, just not to rule until after the election. A little blatant there. But as I said, all the legal scholars had said, nah, they're probably going to do basically what they just did. And which is the normal thing. Oh, they waited the last possible minute to do it, right? And so that's the idea, is to delay. And I think that's what they're planning, is that now remanding it down to the trial judge. They're then going to have hearings and make a decision on what is or isn't personal. The other thing is, their other decision was made, last week on the so-called Enron laws, it's sometimes called. That pretty much kills two of the four charges outright. Okay, unless there's something buried in them that isn't relevant to that law. So now you've got the other two cases, and one of them is fraud against the United States. But there's no financial transaction involved in this. It was simply the claims he made. They're saying he made them and they were knowingly false. Of course, that has to prove that he knew that. How do we know what his state of mind was? I mean, well, we do know that he was told by certain people and his experts and, election expert people he had hired in his campaign. I believe they told him that he didn't really have a good case on the counting and all that. Of course, he believes he did, and so is it a fraud? In this case, is he knowing? Is it that most people thought it wasn't true, or is it he thought it wasn't true? And at any rate, can fraud against the United States be a case of simply making statements? Because I point out that often political figures make inaccurate statements, and maybe knowingly, but they don't get charged with fraud. But if they, presented a bill to the United States government for some services rendered that was not actually rendered, that would be a fraud. So does it have to be financial? I think that's an issue here. The other issue is the First Amendment. Doesn't he have free speech rights? This is political speech, and I think that's highly protected. So I think that's one. And then the other is, I think, it has to do with the idea that he somehow instigated the riot. Some of the thing about talking to Justice Department people on his side of the case, the decision they made also included that was protected by immunity, the communications with the Justice Department. So that may also weaken another aspect of the DC case. So what's left of it that can really be turned into a crime is kind of up in the air. And there will probably be an appeal of whatever this judge decides. I'm sure she'll be as adverse to Trump as possible. And then he'll appeal it, and it will go up the ladder just like it did before, and it will end up probably back to the Supreme Court, and all the time this takes will run out the clock and after the election in all probability. And so it probably never comes to trial before the election, and maybe not even before the outcome of the election. And if he wins and is inaugurated, then presumably his Justice Department could just drop the charge. So that's kind of what we're looking at there. And the other remaining charge that hasn't been killed off, I guess, yet is this idea that he was trying to take away people's rights to vote or something, their voter right case. Again, to me, this is another attempt to take a law which is meant for one purpose, that is sort of vote suppression, trying to do something to prevent people from actually voting, and turning it into his election challenge before the Congress, and say that somehow that was that. And I think they're probably going to try to use testimony from former Vice President Pence in this, because he was apparently trying to get Pence to agree to not count the ballots that he was wanting to dispute. Whereas what Pence actually ended up doing was just going through the formal process of having a vote on them. The idea that Pence himself could have stopped it, of course, I think is wrong. He couldn't have. But at any rate, that may be one of the remaining charges. The question is, does the voter suppression law, which would have to do more with things like putting out false information, like claiming that the election date was a different date than it was and directing it to certain groups, or some other thing of that sort, which could then be somehow might lead certain groups of given political persuasion to be confused and not vote. I mean, there have been things like having excessive, something that would intimidate them, and voter intimidation would be an example of that. But I don't know that what he was doing with respect to this, the election challenge and the things he was trying to get Pence to do, which Pence didn't do, would fall in that category. But we'll see about that. But I'm pretty sure for a DC jury it would. And so, like I said, so this, whatever they decide, now the two surviving aspects of it will probably, be appealed also. It may turn out that the appeal will be something other than immunity also, such as First Amendment and maybe just inappropriate use of a given statute and so forth. But the idea, if you can keep this thing tied up long enough till he would theoretically win the election and be in office, then presumably the Justice Department under his leadership could then drop the case. Or once he gets in there, there's also the rule about prosecuting a sitting president in the Justice Department. At any rate, these things will have to be handled at that time, one way or the other. And I think that's what the court is doing. They're playing that kind of a game, I think. That's the real criticism the Democrats would have, but that's not what they're saying. They're saying that this is going to undermine the system and turn the president into a dictator, which is all nonsense. In fact, it may not totally protect him against the things that are out there. So at any rate, that's kind of my review of the court decision and where we're going on that for the moment. More litigation, more nonsense, but it looks like fundamentally Trump is actually, in spite of my earlier fears months ago, has emerged in a pretty good position where it looks like maybe the Florida case won't come to trial before the election, the documents case. this one probably won't in D.C. And the one in Georgia, the state case in Georgia, looks like it's tied up in appeals. We'll also postpone it to after the election. So all we've got is the one thing in New York, and we'll see what the sentencing is on June the 11th and how aggressive the judge is and what actually happens with this attempt to use this immunity as I think a foothold or kind of a foot in the door to get to federal court more than what it would actually be decided on. So anyway, so I'll be wrapping this up for now. As always, I'll post this on YouTube and Rumble, and the links to my social media accounts are in the description below. So all for now.